Hello, everyone, and welcome to today's webinar featuring Professor Quentin Skinner, someone who is well known to many of you. I'm Pat Parody, the Executive Director of the Center for Constitutional Studies in the Faculty of Law at the University of Alberta, and I will be moderating today's session. So I'd like to begin by thanking Professor Josh Nichols from our faculty who introduced Quentin Skinner to the center, and also to our center staff, Alina Rietsma and Zara Ahmed, for their assistance with coordination around the seminar. And so I am speaking to you today from Edmonton, which is on Treaty 6 territory. The center acknowledges and honors the ancestors, their traditions, and the spirit that first drew Indigenous people, the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Saulteaux, Inuit, and then settlers to this place. We acknowledge the spirit of the ancient and great gathering place that has for thousands of years been a peaceful and spiritual place for trade, ceremony, and celebration, and we call upon the spirit and the intent of treaty to maintain us in a strong and lasting relationship. Now, before I introduce Professor Skinner, I would like to note that the webinar will last about 1 hour and 15 minutes. Professor Skinner will speak for approximately 40 minutes, and then we'll answer as many questions as possible in the time remaining. Now, with respect to questions, the chat function, which you can see at the bottom of your screen, has been disabled, but you may use the question and answer, the Q&A button on the bottom of your screen to ask questions. And attendees will be able to see one another's questions, and therefore, if there's a question you like, you can click on the little thumbs up button by the question, and it will move the question toward the top of the list to give it more prominence. If you wish to ask a question anonymously, you will be provided with the option to do so when you enter your question. You will also receive a short feedback form or survey after the presentation today, and we would appreciate it tremendously if you would take a few moments to fill it in. Your feedback is extremely valuable to us. Lastly, please note that the webinar is being recorded and will be available on our website. And so, to begin, I have to say that we are frankly overjoyed that Professor Quentin Skinner is able to join us today from London, thanks to the wonders of technology. Quentin Skinner is the Barbara Beaumont Professor of the Humanities and co-director of the Center for the Study of the History of Political Thought at Queen Mary University of London. Prior to his current appointment, Professor Skinner was a professor at the University of Cambridge, and he has received visiting appointments at numerous universities, including Princeton, Oxford, Peking University, the University of Chicago, Berkeley, and the University of Amsterdam, just to name a few. He has also won numerous awards and honorary degrees and fellowships. Professor Skinner has lectured and published on various subjects, including intellectual history, philosophy, and political theory. He has written and edited numerous works, including, for example, From Humanism to Hobbes, Studies in Rhetoric and Politics, Thinking About Liberty and Historians' Approach, and Hobbes and Republican Liberty. Many of his publications have been translated into several languages, and he has lectured around the world. There's so much that could be said about Quentin Skinner. Those of you who know him will know that his CV is several pages in length. But we simply do not want to keep you from hearing his presentation. Civil Liberty and Fundamental Rights, a Juridical Perspective. Professor Skinner, would you please begin?
Well, Patricia, thank you so much for these very kind words. I feel really honored to be invited to talk to this seminar, and I'm only sorry that I'm not actually in Canada, especially because I've always had such a good time when I have been there. Still, here I am in 2 dimensions. My aim in this talk is to contrast a prevailing way of thinking about civil liberty with an earlier but now largely rejected tradition of thinking about the same concept. Now, underlying that argument is a view about how the history of legal and political concepts may be of present use to us. I mean, obviously, throughout our history, many concepts have been adapted, redefined, and sometimes abandoned. But one of the values I've come to feel of historical study in legal and political philosophy is not just that it can take the form of an exploration of these abandoned pathways, but can also lead us to wonder if at some point we might have taken the wrong path. And the thesis of this present lecture is that this is indeed what has happened in the case of the concept of civil liberty. May I begin by recalling what I've described as the prevailing way of thinking about liberty? And here I'm thinking of recent Anglophone legal and political thought. Let me just mention two classic statements. One, Isaiah Berlin, two concepts of liberty. Well, one of the concepts, of course, that Berlin considers is that freedom is the name of a kind of moral achievement, a view recently very influentially restated by Charles Taylor. But Berlin sets that aside, as you will know, of course, in favor of claiming that liberty is best understood in purely negative terms as the absence of any moral or physical coercion, and thus as the state of being free from hindrance or interference. Another classic statement of our time, John Rawls, The Beginning of a Theory of Justice, the idea on which his theory is grounded, he tells us, is that to speak of liberty, I mean, it's a theory of justice as equal liberty, so he has to talk about what he thinks liberty means, and he says it is always to refer to the same triadic relationship. That's to say, there has to be an agent, an action, and an end. And an agent is free when they are unimpeded from doing or not doing something. So Berlin and Rawls here completely agree, liberty is absence of interference. Okay, against that orthodoxy, I want to set what I've called a juristic view, a juridical view of freedom. And this I shall want to call in my talk a neo-Roman juridical view. And I use that label because the juridical view I want to talk about today derives entirely from Roman law. So the right place to begin, I think, is with what I've come to think may be the most influential of all the works of legal and political philosophy inherited from antiquity in the West, namely the Digest of Roman Law. Now, within the Digest, the analysis of libertas, liberty, appears in the section entitled Of the Status of Men and Women. Now, that source never ceased to be invoked, but it's crucial that its definitions and arguments were later incorporated, more or less word for word, into the earliest and most influential compilation of English common law, the massive treatise traditionally ascribed to Bracton, dated from the mid-13th century. And that really matters because Bracton's compilation in turn had a formative impact on the common law tradition, and in the hands of legal writers of the early modern period became a cornerstone of English constitutional thought and later of Anglophone constitutional thinking more generally. So let me turn to what I'm going to call this neo-Roman analysis of liberty. Bracton begins by citing the Digest of Roman law for the view, I'm quoting, I'm translating obviously, that the whole of law is concerned either with persons or with things or with actions. And he then adds, still quoting, that since persons are of the greatest importance because all laws are established for persons, we must first consider them and their status. And that clears the way for what Bracton next describes, still quoting the Digest, as the principal and briefest division of the status of persons. And that is, still quoting, all men and women are either liberi homines, free persons, homo of course meaning man or woman in Latin, or else they are servi, slaves. So you cannot, on this account, understand the concept of freedom unless you understand its opposite, slavery. Now that's to confront a horror, but the neo-Roman claim is that if you want to understand liberty, you have to approach it by its negation, and the negation of liberty is slavery. So the question becomes, what does it mean to be a slave? Now the answer, we next learn this from the digest, is that it means to stand in a relationship of dominion to somebody else. But how are we to translate this word dominion, which is perhaps the central term in Roman constitutional thought? Sometimes the word was used to refer to power and sometimes to property. So it's pretty important to know which. Well, in the digest, we're first told that what it means to be a slave is to be dominio subjecita, that is, subject to the dominion of someone else. So their dominion can only mean power. To be a slave is to be subject to the power of someone else. Then it's added over the page that slaves are also persons of whom it can be said redigunta in dominium, that is, reduced to the condition of being dominium. So their dominium can only mean property. A slave is someone reduced to the condition of being the property of someone else. So putting those two legal dicta together, a slave is someone who, in consequence of being someone else's property, is wholly in their power. In other words, a slave is someone who is never able to act entirely according to their own will. Whatever actions you perform, if you're a slave, will always be the outcome both of your volition and the allowance of the dominus, your master. A slave can only act in part because of the silently expressed permission of the master, because the master always has power to forbid or prevent acting. Well, lastly, in the same passage, the jurists also comment on the freedom of the free person, the libertas of the liber homo, by contrast, that is, with the servitude of a slave. And Bracton here begins by citing the jurist Florentinus, quoted in the digest, who lays it down, I quote, that the freedom of free persons consists in being able to exercise their natural power is potestas there, of living as they wish. Vivere ut bellis. The only systematic limitation on their liberty is said to stem from the fact that their behavior may sometimes, I'm quoting again, be prohibited by law or prevented by force. So in other words, a free person is someone who is always able to act according to their own will, unless of course prevented by law or by force, and is consequently, and here the legal phrase has great resonance suddenly for us, doesn't it, is their own master. If you're a free person, you are your own master. You don't have a master, you're your own master. I just want to say at this point, to avoid a possible confusion, I need to interpolate that the legal theorist, the political theorists more, eventually divided over the issue of freedom and the will. Some later exponents of this view of freedom, among whom in the Anglophone tradition, John Locke is the most significant, maintain that the mark of a free person is not that they do what they want, it's that they do what reason dictates. For Locke, anyone who manages to use their reason to control their passions may be said to act freely. But anyone who acts, and note again the phrase, as a slave to the passions, if you are a slave to your passions, you do not act freely. Your action is not free, it is licentious. This crucial distinction between liberty and license. That doesn't interest the jurists. And in this talk, it doesn't interest me because I'm talking about the jurists. For them, the only question is, are your choices autonomous? Autonomy is the key idea. They're not interested in policing the choices you make and hence moralizing the idea of free action. Okay, the Roman jurists conclude their analysis of freedom and slavery there, the beginning of the digest. But a further and connected reflection was offered in antiquity by the Roman moralists and some of the historians. They're interested not so much in the legal question, what it means to be a slave, but in the psychological question, what it means to realize that you're a slave. And the answer to that, I mean, that's a slave society. You could be a slave without knowing it. If you're born a slave, you are a slave, but you don't yet know it. So the answer is, what is it to realize that? Tacitus and Seneca are deeply interested in this question. And the point is, of course, that this cannot fail to be formative of character. A free person can be expected to have a distinctive frankness and confidence. Frank used to mean free. Free means frank. Frank means free. Free of speech, independent of judgment. And as they like to say, capable of looking anyone in the eye. A slave, by contrast, can hardly fail to be servile. How could it be otherwise? As Seneca in particular undermined, the fact that slaves live wholly at the mercy of someone else means that they're going to have to know how to keep out of trouble. So it's not merely the case that all actions of slaves have the character of permissions. They will also be virtually certain to circumscribe their own actions, because they're going to try to make sure that they don't offend. And so the tough thought amongst the ancient moralists is, how can, and the words come together, how can servitude fail to make us servile? Okay, I hope I've now made clear that the basic contention that interests me is the antonym of liberty is not interference. It is subjection to the will of another. And on that account, of course, this is a crucial divide. You can be unfree in the absence of any interference or even any threat of it. Now, that's the basic Roman law view, the basic juridical view. But I need now to note that the digest introduces a complicating distinction. They go on to draw a contrast between those who are able to act, as they put it, sui juris. I mean, as you would still say in the law, sui juris, meaning entirely in your own right, and those who are not sui juris. Well, obviously, in antiquity, the most obvious case of persons who are not sui juris are slaves. But there are now said to be others who, although not slaves, likewise are not able to act without being to some degree under the control of another. So you're now being told this: to be a slave is to lack liberty, but to lack liberty is not necessarily to be a slave. Well, as it turns out, the digest is interested only in one such class of persons, and that is children below the age of adulthood. But conceptually, the distinction is of the utmost importance, because otherwise there's a danger of diluting the concept of slavery by arguing that anyone subject to the will of somebody else has been enslaved. And it must be admitted that that dilution in the heyday of this juristic understanding of freedom, that undoubtedly occurred. I mean, take only the most celebrated example. When in 1765, the British Parliament began to tax the American colonies, even though the colonists had no representation in Parliament, the resulting complaint of the colonies was that that left them subject to an arbitrary will, the will of Parliament, which they had no role in forming, and were just wholly subject to an alien will. But that, they said, makes us slaves. And that was, of course, the colonial case. But even at the time, they were ridiculed for comparing their predicament with that of the actual slaves, which many of them possessed. Okay, there's as brief account as I can give of the basic juridical idea, the neo-Roman idea of liberty. Let me just round off by underlying the basic structure, because I think this has been quite widely misunderstood. This is a theory of freedom that begins not with the question, what does it mean to act freely, but with the question, what does it mean to be a free person? And that is because, on the account I've given, you can never act freely unless you are a free person. But it's equally crucial that you can remain a free person while nevertheless being prevented from acting freely. That's the structure you've got to get right. A free person who is, for example, legally coerced will obviously forfeit some freedom. I mean, if they're convicted of a crime, they may be imprisoned. And that it would be ludicrous to say that's not a deprivation of freedom. But the constraint they experience does nothing to take away their underlying status as a free person. By contrast, a free person who comes subject to the will of another, as I've said, loses any capacity to act freely. Now, what the Neo-Roman theory wants you to accept is that that loss of autonomy is incomparably a worse deprivation of freedom than occasional acts of interference. You could deny that, of course. I mean, I haven't seen any critic of the theory deny it, but you could deny that. But that has to be the basic juridical claim, that what's crucial to freedom is not being subject to the will of another. Freedom is a will-will relationship. Okay, there's my exposition. Now I want to turn to the theory of rights that became associated with this view of freedom. I need to begin by noting an implication of the analysis I've given, which is that to be a free person, you must not merely be free from interference, you must be free from the possibility of interference. That's because if someone could interfere with your choices if they decided to do so, that's to say you have a master, but that's to say you're a slave. Okay. Now that is a claim that several contemporary critics of the Neo-Roman theory have objected to very strongly. Here I'm thinking especially of Professor Brennan, Professor Lumasky in their response to Philip Pettit's restatement of what I'm calling the Neo-Roman case. By the way, since I've mentioned Philip Pettit, let me add that he has, in my view, made by far the most important contribution to reviving what he calls a Republican view of freedom, what I'm calling the juridical or Neo-Roman view of freedom. But Brennan and Lumasky are among many who have sought to dismiss Pettit's case. And their objection is that no citizen can expect to be granted the security, the impossibility of interference of which Pettit speaks. Because to live amongst others is inescapably to be vulnerable to arbitrary encroachment and to violence. So the objection is the theory is asking for something which is known by us all to be impossible. Well, that's obviously right. But the objection is not one that the original Neo-Roman writers failed to confront. And by the time we reach the early modern heyday of Neo-Romanism, what you find acknowledged is, of course, no state can secure all its citizens from all assaults on their liberty at all times. The response of the Neo-Roman theorists, however, is to say, okay, we reformulate the basic claim about civil liberty in the form of a doctrine of what they began to call fundamental rights. Now, here they open up a really important distinction in early modern legal thinking. I certainly don't need to remind you of this, that in the Anglophone tradition, a standard way of thinking about a right has been to suppose that it's a moral claim that originates outside the state and is everywhere the same. So a basic duty of the state on this very familiar account is to uphold these rights of nature, what eventually came to be called natural rights, or much more recently, human rights. And the state has that as a duty on pain of losing legitimacy. Now, by contrast with that, the juridical story introduces the concept of a fundamental right. Now, in Anglophone constitutional theory, that vocabulary is first introduced. I've done a lot of work on this. It's first introduced with extreme suddenness by the parliamentary opposition to the British monarchy just before the outbreak of the civil wars in the 1640s. And by the time you come to the settlement of the British Constitution after the Revolution of 1688, a list of what were taken to be the fundamental rights was enshrined in what was called the Bill of Rights, which became statutory in 1689, and by the way, is still statutory in British law. Now, these rights are avowedly not natural rights, certainly not human rights. They are a social construction. The list is offered, that is, simply as an encapsulation of what members of a specific civil association have taken over a long tract of time to be essential to the fulfillment of their basic purposes. So, and here's the crucial point, the status of being a free person comes to be equated with the capacity to exercise freedom of choice, at least in relation to these fundamental rights. And the list of these rights that figures in the crucial early modern common law texts, Petition of Right, down to the Bill of Rights, are three. The right to life, and that is a right to self-defense, of course, vim vi licet repellere, again, the Roman law. Second, the right to personal liberty, again, the Roman law, that is the right to habeas corpus. And thirdly, the right to hold property, including, crucially, the property of your own person. If you don't own yourself, you're a slave. So you have to own your person. Any society which lacks security for those rights is a nation of slaves. And that's what's said in the Bill of Rights, still statutory law, where I'm standing in London. Okay, there is the neo-Roman story. And what I want now to do in the last minutes of this talk is to conclude by highlighting what seemed to me the positive value of that view of thinking in our contemporary world. And here I just want to make 3 points. One value I've obviously just touched upon is that the theory provides us, I think, with a way of thinking about what we've come to call human rights. It is arguably a lot more useful, frankly, than most current accounts. Among recent political philosophers, certainly in Anglophone philosophy, these rights still tend to be treated as universal moral demands that everyone can equally make upon everyone else. I mean, think again of Rawls's argument in the theory of justice. That's how rights are construed there. Or think of Marcel Nussbaum's and Amartya Sen's work, analyzing rights in terms of what they call human capabilities. The obvious problem with this approach has been much noted is that it becomes very hard to prevent this list of human rights from inflating into a description of everything that we judge to be necessary for a good life. Very hard to prevent that inflation. That being so, it's not at all surprising that a reaction has been to propose that the idea of honoring a human right might instead be limited to furnishing a number of basic goods that could feasibly be provided within existing institutional frameworks. That's the approach you find, for example, in James Griffin's book on human rights, or Podgy's book, World Poverty and Human Rights. But there's also a problem, a well-known problem, is there not, with that approach, which is that it's so ready to valorize existing institutional arrangements, as if it's proper to give them precedence, whereas you might think that is what had to be shown. Well, there's a kind of analytical stalemate in the discussion of human rights, but as some political theorists have begun to emphasize, that is a stalemate from which the juridical account I've given can perhaps rescue us. And here I'm thinking in particular, very important recent work by Professor Lena Haldenius, her critique of current thinking about human rights. She's professor of the Center for Human Rights at the University of Lund. As Haldenius points out, the neo-Roman view would be that a good way of thinking about human rights without inflating them and also without valorizing existing institutions would be to say they're the traditional list of fundamental rights. That is, you equate them with the basic liberties which arise within political associations and require to be secured if we are to be protected from becoming subject to the will of anyone else. So the outcome would be a list of co-enjoyable rights that all legitimate governments would, on pain of being branded tyrannical, make it their business to uphold, not just against interference, but against possible interference. Now, surely that's a concept that deserves to be further explored. And when I go back to thinking about the Bill of Rights, I'm so struck that it says this is not only going to be enshrined in statute, which it was in 1689, but it may never be removed. That's to say that what's being enshrined is necessities in this society. So there's my first thought. A second and related value I see in the Neo-Roman theory is that it restores the connection between securing liberty and upholding democratic forms of government. I don't think it's been sufficiently admitted that one outcome of the triumph of liberalism, and therefore a liberal view of freedom, such that you find across the spectrum of liberal to libertarian thinking in Anglophone philosophy, is that it severed that link. Let me quote Isaiah Berlin, for example, once again. This is two concepts of liberty. I'm reading. There is no necessary connection between individual liberty and democratic rule. Liberty consists in not being interfered with by others, and so is concerned with an area of control, not its source. So note the contrast with the juridical view, which insists that you can never hope to live as a free person except under a constitution of which two things can be said. One, we've just seen, you must be secured in the enjoyment of fundamental rights. It must be impossible for them to be taken away. And the other is, and here you get the constitutional point, by a process of equal representation, it must be possible for each citizen to have their voice equally heard with others in the making of the laws under which they live, because otherwise those laws cannot be seen as an expression of their will. And the reason for that requirement, of course, carries us to the heart of the Neo-Roman story. If the laws do not express my will, at least by representation, then they must express somebody else's will. But then I must be subject to that will. But that's the definition of slavery. So popular sovereignty is mandated by this way of thinking about civil liberty. And that seems to me to give a Democrat a kind of prima facie reason for adopting the juridical instead of the liberal view. My third and final claim is that a further value of the Neo-Roman theory seems to me to stem from its distinguishing emphasis on the claim that you can never be unfree, even in the absence of any acts of interference, and hence on the capacity of silent forms of power to take away freedom of choice. Okay, no one has interfered, but there may be silent forms of power which take away your freedom. This is a very distinctive claim of the jurists. Let me give you a contemporary example. Consider the extent to which deunionized workforces, or even more dramatically, undocumented aliens, currently live and work at the mercy of employers who have power to dismiss them at will. Or consider a yet more disturbing and analogous case, in this country now outrageous level, or always outrageous, but now terrifying levels of domestic violence. The loss of liberty suffered in such circumstances need not stem from overt acts of intimidation or interference. They may result, but the loss of liberty already stems from the mere fact that if you are an undocumented alien, a deunionized workforce, a battered woman, stems from the mere fact of living in subjection to the will of someone else. Because that has the virtually unavoidable consequence, as we noted, that you're going to have to make sure that you avoid acting in any way that's going to cause offense. You're pressed into servility. How could it be otherwise? And so you get what Marx would call slave contracts. Here's another example, very much from our society. A further silent form of power arises from the growth of surveillance by corporations and states. How should we react, for example, to the current business models of digital and media companies? They provide free services that enable them covertly to acquire swathes of data about our personal preferences. So we're just left subject in an important domain of our lives to an unaccountable form of power, which may or may not be used for our benefit, and over which we have no control. Now, this is known, of course, to be a danger. We all know this. But I'm so struck by the fact that in liberal commentary, this is construed as a danger to privacy. I'm saying it's a danger to freedom. That the liberals miss the point here. Liberalism is very bad at dealing with silent power. Why? Because it's looking for interference, but this power is silent. It is the mere fact of living under such an arbitrary form of power that constitutes a threat, not just to privacy, but to our standing as free persons. If you hand over your personal data to people who can thereafter use it for undisclosed purposes, you have to that degree made yourself dependent upon their will. And what the neo-Roman juristic analysis asks you to recognize is that that can never be a wise move. You may think you're gaining many benefits, but reflect on the crucial point, which is you don't know what could happen. You may think, well, nothing bad is going to happen. But that's the wrong answer. The question is, what could happen? That's what it is to be subject to arbitrary power. Can I end on a more cheerful note, since I see I've got 2 minutes left? I think there are very good positive reasons for wanting to be an exponent of a juridical view of thinking about freedom and not a liberal view of thinking about freedom, which you can see if you reflect on it as good for you. I mean, it's an instrumental good to the achievement of many of your other purposes. It's instrumental to being able to look people in the eye, to being able, therefore, to negotiate on your own terms and make decisions in your own time, and therefore have a life in which there's a certain timeliness about your behavior. But also it's an intrinsic good, I've come to think. It's impossible to think of someone as a free person in the way that I've described without seeing that this is someone who would have a certain sense of self-worth. And it would be connected with their enjoying and striving for and trying to maintain institutionally just that view of what it is to be a free person. So for all those reasons, I think it's time for us, here's the polemical conclusion, if you can bear it, let's call time on the classical liberal view that freedom is absence interference. That's just not getting us where we need to be. Thank you very much. Well, Patricia, I spoke for 40 minutes. At least I did do that right.
You were bang on in terms of your time, Quentin. That was marvelous. Thank you very much. Brilliant. All right. Well, now I see we have questions, and I'll just now just to let the audience know, what I'm going to do is just ask the questions in the order in which they have been submitted. And this is something that Professor Skinner has asked me to do. So I'm going to follow that request. And so just to remind you all that if you do want to ask a question, use the Q&A button on the bottom of your screen. And if you see a question that you like or that is similar to one that you would like to ask, just simply press the little thumbs up button and it will move the question up in terms of its sequence. So then let us begin with the first question. Now, do you think this distinction between the legal, that is subjection-based, and the humanist, interference-based conceptions of freedom makes sense when discussing not the freedom of persons, but the freedom of groups, that is states, peoples, cities, etc.? Persons within a group are always under the rule of the will of others in any constitutional structure. No?
This is a very good question. And part of the answer I gave towards the end of my paper, which is that it is, of course, a fundamental constitutional aspiration of people who adopt a juridical view of freedom to answer to your question, no question mark, is to say no, exclamation mark. You have to have a constitutional arrangement in which you are able to see your will reflected. So there has to be an arrangement which is based on a theory of popular sovereignty. Furthermore, it cannot be a Rousseauian view of popular sovereignty in which effectively the general will, which can only be the majoritarian will, is equated with the common good. The juridical view would be that that is an extraordinary naivety about human nature, and that if we are going to make sure that I have a strong answer to your question, we would not only be insisting on a theory of popular sovereignty, but one in which there is a very robust constitutional protection for minority rights. So then I think there is no difficulty about answering in the affirmative to your question. This works for groups just as well as it works for individuals, the profound reason for that being that the state is the name of a person. The state is a fictional person, of course, because it cannot itself act, but it's the state that taxes you and the state that puts you in jail. And if you want to understand contemporary legal theory, what you need to make sense of is, how can a fiction put you in jail? Well, the answer is by having a good theory of representation. If the state is represented so that the actions of some other person, natural person, can claim to be the actions of the state, in as much as this person is acting in the name of the other person, then there's no problem extending this to groups. But then who is the person that can claim the right to act in the name of the person of the state? And the only answer to that that can be given is the people. They are a group also. They are a group in as much as a multitude is turned into a people if it is authorizing an action which shall count as an act of their will. So there is a kind of very abstract way of stating a constitutional theory.
Thank you. All right. Now,
I wonder if that satisfied the questioner. Do we get to go back to the questioner?
With the questioner, this is a professor in our own faculty. Now, I don't know if he's still on. I don't see his, well, we'll see. He may decide to respond in some way. And so another question, and I'm just going to jump here because this is a question by the same person. So I'm going to jump to the next question. Hello, Professor Skinner. It is a great pleasure and honor to hear you speak today. I was wondering to what extent the juridical tradition, as you have described it, has become inflected through the tradition of democracy, such that essential democratic rights are enforceable against legislatures, regardless of any positive expression of those rights. Is this proposition, if this proposition can be accepted, could one go further and argue that the essentials of life necessary to secure democratic participation are also enforceable against legislatures?
Well, to go back to the character of the constitutional theory that is mandated, required by this way of thinking about what it is to be a free person, and thus within a civil association, how can you be a free citizen if you're subject to the law, is quite simply that it has to be a democracy. This is a democratic theory of liberty, in as much as any constitutional arrangement in which I do not see my will reflected in the law is one in which I am in a state of dependence. So I can't see how to answer your question better than to say that, as I've just said, this theory is a democratic theory of civil and political liberty. It requires democracy to be its vehicle for upholding freedom. And notice that the upholding of freedom understood as equal absence of dependence upon the will of others, it is it's not a populist, but it's an inherently egalitarian form of democracy. That's what's required.
Next question then, thank you. Does the juridical view of freedom recognize not only that power can operate silently, but that freedom positively requires some sort of power, at least power of self-determination?
Yes. Here, the liberal and I'm calling it liberal because I think of Berlin and Rawls and these people as liberals, but let's call it whatever you like. The prevailing view of freedom is here at one with the juridical view that I've talked about, because both issue in an understanding of what it is to act freely. Now, what's very important in the juridical view is the claim, it's a very distinctive claim to the theory, that you'll go all wrong if you start by asking about free action. You should ask instead about what it means to be a free person, because only free persons act freely. And so the two are connected up together. They're not connected up together, of course, in the liberal view, because that is a view about freedom of action, and your action is free if it's not interfered with. Now, I've tried to show why that's completely insufficient. And I've done that not by simply adding the two together, but by pointing out that there are some acts which reflect the fact that you're not a free person. And there are other acts that you can't perform that do not. If you put that the other way around, though, what you find is that the two theories want to say the same thing. An action is free if it is the act of a free person. That's to say, it expresses your will. So autonomy is the outcome for both theories. So freedom, as you put it in your question, does indeed require a certain sort of power. That's to say, the power to exercise an autonomous will. Now, that power can be taken away by interference. I mean, the will cannot be exercised at all because it's impaired, it's interfered with, it's hindered. Or it can be taken away by subjection. But they both come out at the same point, wanting to say, yes, there is a power of the will that has to be susceptible of being exercised, and the outcome has to be autonomy. And there the two theories don't disagree. And I quoted Florentinus saying, what it is to be a free person, positively, is you can do what you like. You're not subject to anyone else. You don't have to worry about anyone else. You can do what you like, unless, of course, it's against the law, as he says.
Thank you. All right, next question. If rights, such as those protected in the post-1688 settlement, are considered fundamental, how can this notion be reconciled with the parallel notion in Anglophone thought on the sovereignty of Parliament as described by Blackstone? If Parliament can override these rights, as they have, just how are those rights beyond the sovereignty of Parliament?
Very good, very, very important question, and takes me back to the importance of look, there are two ways of institutionalizing the idea that the people must rule. And one is the Rousseauvian story, which is to say, there must be a single legislative which represents all the people equally, and it must act as sovereign and therefore without appeal. Now, that is not at all the view, and of course it's enormously debated in the 18th century. That is not at all the view that the people that I've been describing would want to accept. They would want to say, as well as such a legislature, which we can call sovereign for the purposes of legislation, there has to be a separation of powers. There therefore has to be an independently appointed judicature, independent from any legislative interference as to appointments or as to its conduct. It's a self-regulating, freestanding institution of the state. Now, it has power to strike down legislation. And when our so-called Prime Minister, Boris Johnson, prorogued Parliament and did so for a period which was unconstitutional, the Supreme Court of the United Kingdom simply told him to reconvene Parliament. It simply struck it down. This caused a tremendous furore, but it brought out the fact that the British Constitution is a mixed constitution. It's not a Rousseauvian constitution, as Johnson was behaving as if it was. It is not for the legislature simply to decide. Now, of course, in practice, legislators get away with a lot of things. And if you have a pandemic, it turns out that they rule by fiat. I've never seen such a Hobbesian constitutional setup as I see now in the so-called democracies of the West, in which highly authoritarian people like Monsieur Macron or the Prime Minister of Great Britain simply come on television and say, don't do this, do that, you must do that, you can't do that. They haven't asked Parliament. There's been no legislation about this. It's completely discretionary. It's what the juristic writers would call arbitrary power. We didn't sign on for this. And then you say, well, it's an emergency. Well, Carl Schmitt has much to say about the danger of calling things emergencies. You can find that you've got a permanent emergency, and that is an authoritarian regime. So to set that horrible possibility aside, it was always the aspiration of the settlement of the British Constitution in 1688 and the so-called Westminster model that flows from that is that there will be at the heart of it, and this comes right back to your question, there will be at the heart of it the claim that there are certain features of legislation which cannot be repealed. And if you do try to repeal them, there will have to be an independent judiciary to uphold them. And in the case of the Bill of Rights, that is explicitly specified. That rights of life, I mean, habeas corpus, the right of self-defense, property in your own person, no slavery. These are rights which cannot be repealed. They're fundamental. And that is actually in the Constitution. So it is not a parliamentary sovereignty, except that there is also legal sovereignty. Thank goodness. I mean, if this was a lecture hall, I would ask how many, hands up, how many people agree with Rousseau? And that's the wrong answer, I would say.
Okay. Too bad we're not in person. It's a shame. Now here's the next question. If juridical liberty requires that one be subject only to the laws that accord with one's will, what does that imply about the effects of being subject to laws with which one disagrees or voted against?
Vital, absolutely crucial point. Any democracy cannot avoid an element of majoritarianism. I mean, that's obviously built into it. The question is its legitimacy and its limits. Now, I think what you have to recognize in politics is what you have to recognize in all the meetings that we take part in which your faculty or department is trying to make a decision to change the syllabus or to appoint a new colleague or something like that. It will assemble a committee. This committee assembles on an absolutely crucial legal understanding, which is usually left implicit, which is that I'm not saying the majority is right. I am having to say that the majority will has to, as the law says, embrace the minority. Now, there are circumstances in which you absolutely don't want that to be the outcome. And one of the things which liberalism is very good at is seeing that the theory of rights is there to protect minority rights. But in the circumstances in which I've described, you have ex ante agreed a procedure. And you have to agree that procedure, because otherwise you can't make a decision. If you insist on a decision being unanimous, you're not going to get many decisions. The celebrated problem of the Polish Diet, which in the 16th century decided that all legislation would have to be unanimously agreed, because otherwise somebody would be subject to the will of someone else, and it was against what they desired. They couldn't legislate. So what you have to build into this, I mean, this is Constitutional Theory 101, is some prior recognition of the rules of the game. And you then have to abide by those rules of the game. You won't always get your way, but you won't be able to say that you have been enslaved because you authorized the rule.
Now, I hope I'm getting these in order as we promised we would. I know the questions are being...
Oh, I mean, you're in charge, Patricia.
All right, but I'm just, some of the questions are moving up and I hope I don't miss anyone. That's the only thing. So I'm going to ask this question. Regarding the response to the Coleman question, and that was the, I don't know which question that was, separate independent judiciary that can overrule Parliament. What would your comment be regarding the dialogue theory, where Parliament and judiciary each validly interpret the Constitution, and the legislative response to the judiciary and judicial response to the legislature creates a constitutional dialogue? And that is, you know, for example, what Peter Hogg and has written about in Canada, Manfredi, etc. So
yes, yes. Well, in the way that most modern democracies at the moment in the West organize their party politics, the dialogue happens within the legislature. I mean, there will be a party that commands a majority. Very commonly, that will have to be a coalition party. Very unusual, the British case, where there are two dominant parties, as in the United States of America. Mostly, of course, these will have to be coalitions, and it's nothing but dialogue. The whole thing has to be done by a kind of endless dialogue between groups, none of whom constitute a majority in themselves. If you have a two-party system which is very strong, you can even manage to acquit someone who seems to have led an insurrection against his own state because people vote along party lines. But that, of course, is just to point to an extreme weakness of two-party government. There might be much to be said for a much more unending dialogue of the kind that in polities I'm used to in continental Europe. It's of course much more fractious and less stable, but it answers to questions about freedom more satisfactorily.
How should the civic Republican theory deal with what Matthew Kramer has called the coalition problem? That is, if 10 people stand in one room, each individual is subject to the will of the 9 others not ganging up against them. Aren't we all subject to everyone's will at any moment?
Is Matt's not here. Matt is a real nuisance in my life. He's extremely clever, and we can never come to agree on anything. It's crucial to distinguish the question of what the will-will relationship is that we're talking about. To be subject to somebody else's will is to be in an existential condition. To have your will contradicted is another matter. I can have my will contradicted, although I'm not existentially unfree, and conversely. It's absolutely crucial to see that there are these two components. Matt Kramer's book on freedom, which is very brilliant, is a Hobbesian view of freedom, I mean, quite explicitly. And so much so that Matt seems to wish to say, like Hobbes, that because there's no freedom of the will, unfreedom can only be brought about by physical means. It can't be brought about by coercive or psychological means. So it's a very rigorous positivistic understanding that freedom is absence of physical interference. Now, in the 10 people in the room, I mean, what does he want to say about the 10 people in the room? Not that I'm in the existential condition of being subject to the will of anyone. I remain a free person, even if they all set upon me and beat me up. I mean, of course, that has gravely undermined my freedom of action. I may have been put out of action. But we're talking about a free person.
If the will of the people cannot overrule the judiciary, then doesn't that create another type of dictatorship?
Yeah, if this questioner can perfect a constitution for us, that would be wonderful. I do not know of any constitutional system which is perfect at the value of maximizing liberty. I've put before you a juridical account of what form of constitution will most nearly come to that ideal. But of course, it's not an ideal. It has to be practically workable. And the relationship between legislatures and judiciaries is endlessly contested. And in the Westminster model, each is capable, especially as there are usually lots of lawyers in legislative, each is capable of accusing the other of tyranny and incompetence. And that goes on all the time. I feel a bit kind of Machiavellian about that in the sense of Machiavelli's Discorsi, that kind of endless debate is probably not to be discouraged. That is simply showing that everyone is being asked really to reflect upon these principles. So the judiciary is asking that of the legislative, and conversely. I don't see how to improve on that. I really don't myself see how to improve upon some model of a mixed constitution under democracy with the separation of powers. I think the separation of powers is absolutely crucial to freedom. But of course, it's not an ideal theory. In fact, I'm trying to say that is not an ideal theory.
All right, so you described how in the Neo-Roman case, children were the single example of a group caught between the condition of liberty and slavery. How would children fit within a modern juridical view of liberty? As it is, the age of majority is somewhat arbitrary. Therefore, are not children as a group unjustifiably subjected to the arbitrary power of others?
Yes, they are. Yeah, that's the answer. Yeah, I don't know about unjustifiably. But yes, it's been extremely important to most legal systems to raise this question of the sui juris. That's why the concept of being sui juris is so central to our juristic discourse today. The case that the Roman law was most interested in was patriarchal power, simply because under Roman law, patriarchal power was potentially enormous. It included the power of life and death, for example. So it was seriously interested in having a law about the rights and duties of parents. But if you were to ask later juridical writers writing about this issue, who is sui juris, the list, of course, is much more extensive. It wasn't crucial to my argument to expand on that list, but let me do so now. The traditional list that you would find in later writers would include children, of course, but it would also, I'm sorry to say, include wives, because the marriage contract is a contract, but is a contract of alienation of property on the part of the woman. And early modern societies were perfectly happy about that. Women, that's to say, did not have a will. They didn't have a testamentary will. There's a wonderful pun going on there. Just as there is with children, of course, the Latin word for children is liberi, the free. So there are jokes in the law. So in the case of testament, in English law, it was not until the 1870s that women were given a testamentary will. That's to say, they had their own will. They could make a will, because they had a will. But in English law before then, women would have been included along with the children. And then, of course, wards. There was even a court of wards. Wards are not sui juris because they're underage, or they may be of age, but about to inherit such a giant sum of money that there's thought to be a good idea to have wardship beyond the age of majority. And so there was a court of wards which dealt with this. So wards is another case. And another case is the insane. The insane are not sui juris. And somebody must speak for them because they cannot be expected to speak for themselves. And so all legal systems now have extremely elaborate arrangements to be made about what is to be done in the case. Of course, now that people live so much longer, it's so much more important because you have to be able to take on the powers of an attorney in the name of somebody else, simply because they have become demented. And so the list is not a short one. None of these people are slaves, but none of them are sui juris. So they're not completely free persons. They are to some degree under the will of somebody else. To be a slave is to be in every dimension of your life, every domain of your life, under the will of somebody else. That's slavery. But not to be sui juris is in some domains of your life to be like a slave. And the law was surely right and remains right to make these distinctions.
Okay. This person would like to hear more about the history of the notion of rights. In particular, how does Hobbes's rather odd to our ears notion of the right of nature as a kind of power fit into the neo-Roman view of the free person? Is he playing on the thought that giving up the right of nature actually secures us more power in some sense? And just to be clear, I'm not supposing that there is some positive lesson to be drawn directly from Hobbes.
Well, I think we talked earlier about what it is to have a good theory of representation, and Hobbes seems to me, an absolutely ideal theory of representation, that usually we've gone for the wrong metaphor. We've thought that it's to do with resemblance, and that representation is picturing, whereas Hobbes says the metaphor is theatre. Representation is acting. I'm acting for you. So I'm not against the importance of some of what Hobbes says. Your question is a really interesting one to me. And Hobbes, of course, is someone who thinks, like many natural jurisprudential writers do of the 17th century, he's drawing somewhat here on Grotius. And then the great statement of the Hobbesian case that became incredibly influential in continental Europe is Pufendorf's in 1672 in the De Jure Naturae, the De Jure Naturae. And that is that human nature is such that outside the state, all you can say outside the state is that everyone has all their own rights. Everyone, and that in the juristic sense, everyone has the right to do everything. There's no law. But the point is that that's not livable. If everyone is equal and everyone has equal powers, then that's war, as Hobbes says. So you have to give up those rights. They cannot survive into civil association. And what it is to have a civil association is to agree to give up these rights. Now you get them back, but you don't get them back as natural rights, you get them back as civil rights. Now, what is a civil right for Hobbes? It is, as he beautifully puts it, the silence of the law. If there is a law saying you may not do X, that's to say you have an obligation not to do X. You have no right to do X. And he gets very vehement about this. That's what right and obligation is all about. If there's a law saying you must drive on the left, then if you drive on the right, we'll stop you. And that's the law. You have no right, you have an obligation to do something else. So what a right is simply an absence of obligation. And if there is no obligation, you have the right due to the silence of the law. That's not a natural right, because the law could think, well, actually, it'd be much better if we didn't drive on the left, let's all drive on the right. So now the law has changed. So now it's forbidden to do what used to be required. Hobbes is very good on all of this, of course, but the fundamental point that he wants to make is Natural rights, forget it. I mean, natural rights are just a way of killing yourself off. Natural rights are lethal. What you want is civil rights. Civil rights are silences of the law. So there is Hobbes's understanding of the concept of a right. He can't bear this idea that it's a fundamental law. He hates the lawyers. And of course, he completely repudiates their theory of freedom. For Hobbes, I would say, is the man who, the writer who absolutely classically asks the question, what is freedom? And says, I'm quoting beginning of chapter 21 of Leviathan, liberty or freedom is absence of external impediments to motion. That's what it is. Notice, he agrees with Matt Kramer. It has to be physical, absence of an external impediment to motion, something stopping you doing something.
Okay, we don't have a lot of time left. And so I thought maybe we will ask you this question. It's sort of a question, it's a bit of a critique. And so this is what this audience member asks, or states, the entire argument presented is somewhat misleading because without understanding and intelligence, the greatest restriction of the individual is ignorance. The greater the complexity of arguments, such as the ones presented, only exacerbates this situation. Suggesting that the way the law defines freedom actually impacts actual freedom is only possible when fundamental needs such as food and personal security are already in place. As such, an actual slave may have greater freedom than a free man. If you fail to recognize the impact of circumstance on freedom, you will never understand why law does not have a consistent effect on all individuals. And this person ends by saying the last statements regarding silent power are absolutely correct. The ignorance of this is ultimately very dangerous. You have been given the freedom to become a slave to the digital world.
Well, thank you for those last comments. They're very important to me. That I'm astonished at our insouciance about the digital world. We're beginning to see that this has been a huge mistake because these people now have far more power than states. Do we intend that? But, you know, it falls to the media company to say that President Trump shall not be heard. So his main mode of communication is cut off by a media company. Maybe it was right, maybe it was wrong, but where is that in the Constitution? These companies are wielding extraordinary levels of silent power. And I think that's where I really indict liberalism. It just is no good at thinking about silent power because they want to, the question is, well, who's doing the interference? And I'm asking, you know, who is in the existential condition of being subject to the will of another? I don't see, by the way, to go back to the first part of your remarks, that that's complex. I mean, it's not existentially complex. It's very easy to recognize when you're in the position of being subject to somebody else's will. And when I gave a version of this lecture in the United States and somebody asked a similar question, I said, hands up how many of the faculty don't have tenure? And they all got the point. There are lots of things you just find it would be very difficult for you to say. So you're a slave. That's not complex. It's an absolutely fundamental existential predicament. I'm saying we want a society in which that's minimized.
Now, how are you doing, Professor Skinner? Because we're at...
It's 8:15 in the evening.
Yes.
And at some point, I shall want to have some supper.
All right, then let us bring this to a close.
No, I'm joking. I think these questions have been outstanding and complex for me, and also very touchingly show that people have really listened. I'm extremely grateful for them. If you have one final one you'd like to put to me, then I'd be happy.
All right, well, we'll put this last one to you then. And now that we live in the age of surveillance capitalism, and he cites Zuboff.
Yes, indeed.
And our liberty is in some important respects interfered with to a massive degree by the large digital platform corporations. How can the Canadian Charter of Rights protect our liberty adequately, the Charter being limited to constraints on government?
Yeah, very good. Well, by the way, Shoshana Zuboff's book, The Age of Surveillance Capitalism, which came out in 2019, is really required reading for those who feel insouciant about digital companies and everything that goes with surveillance capitalism. It's a really remarkable piece of scholarship. Well, I'm afraid I'm going to end on a very lame note because I don't know enough about the Charter. Charters of rights, on the account that I've given, would have to be, in order to do any work, would have to be charters of fundamental rights, because it's no use saying that it's a charter unless the right, it's not just the case that the right is not interfered with, but it must be impossible for the right to be interfered with. That's a very stringent demand to make a common constitution. But the juridical account I've given is absolutely unambiguous about that. It must be impossible, because if it is possible, that's what tyranny is. We live in dangerous times.
Now that is quite a way to end. We live in dangerous times. Well, thank you so much. I'm sorry to the people we cannot, whose questions we can't answer, but I think everyone understands that you've been going for quite some time, and it's much later there than it is here in Canada. So Professor Skinner, I just want to thank you so much for this absolutely interesting, thought-provoking discussion. You've brought up so many issues that are so relevant to our times. You've gone from, you know, the historical to the present in so many fundamental ways. I just can't thank you enough. I mean, so I want to thank you very much. I want to thank our audience members for engaging with Professor Skinner and asking these questions. And to remind you all to please answer the little survey that will be sent your way. We do very much appreciate your feedback. And so on that note, then I will just thank you again and wish you a very pleasant meal and happy rest of the day.
Well, thank you. I've enjoyed this so much and I've learned a lot. And it's a great privilege to have been asked to do this, and I'm extremely grateful. Thank you, Patricia. Thank you very much.
Just before you go, sorry to interrupt you, but did you not say you were writing a book?
Yes, I'm writing a book about the fall of the Free State. I'm writing a book about when it was and why it was that the view that we should think about freedom as being a status of persons got usurped by the view that we should instead think about it as a predicate of actions. And there's a narrative to be told there. And of course, it's a narrative, in my judgment, of loss, but it is very understandable why people preferred the idea that instead of having something called a fair contract that respected the equality of participants, you had a contract in which nobody was coerced.
Well, we look forward to that.
Yeah, well, yeah. It's a story, it's a tragedy. It doesn't come out well.
Okay.
Well, thank you very much.
Well, thank you very much, and thank you to everyone who participated.
Yeah, thank you all.